First of all, thank you everyone for coming, and I want to especially thank our panelists here. I've actually have a little bit of a personal connection with everyone on this panel, which is fun for me. I have not met Ruben before, but he works at where I used to work. At the National Immigrant Justice Center. Anna and I have also known each other over the years as immigration colleagues here in the Twin Cities, and I got to know Julie quite well through a local, through a client of mine and through a local movement, Release Minnesota 8, when she was over at the National Immigration Project and now is starting a new endeavor at Just Futures. So we just heard from historians. We heard about social justice movements. We heard about sort of the intersection of xenophobia and racism, the eugenics movement, Jewish refugees, really sort of abstract, big concepts, big things, right? So now, of course, my panel was, we're gonna shrink it down a little bit. We're going to talk a little bit more about specific tools, specific mechanisms, and things that everyone, as I would like to think about it is, when we talk about immigration enforcement, when we talk about what's going on, the devil really is in the details. Like, what are the tools that are being used, and what are the ways in which we can respond if we don't think they're being used in a just manner, right? And so one thing we wanted to focus this a little bit is, this is a sort of immigration enforcement that's happening in our backyard, right? We can see the news. I personally, it's just heart-wrenching when you see images of what's happening at the border, and I have a number of friends who do work down there, and I know we've brought students down quite often down to the border in Harlingen. And of course, it's heartbreaking and it's heart-wrenching. And at the same time, I have to remind myself that there is plenty of work to do here. There is plenty of work to do in terms of immigration enforcement in our backyard. And it's not a hierarchy, right? It's not like this versus this. It really is, in many ways, for me, I've had to come to think about it as this is where I'm still needed, and this is where I can still do work that I believe in, and so this is where I am. Sometimes it's not an easy choice, but sometimes I think it can be really important and meaningful. So today what we're going to talk about is, how does this black box of immigration enforcement work? What are the tools that are used, right? A lot of the times when I talk to people about immigration and I talk about deportation, we hear it viscerally from the news. We hear about what this administration has talked about, the words they use in terms of criminality. But really, how does that translate to more people being put into immigration detention now than ever before? How does that translate to people from our communities ending up in the deportation system, and what it is that we can do about it? So that's going to be focused right now in this panel, and we kind of had a mutual agreement. We're going to kind of speak. We're going to go through each panelist, and then we're going to go ahead and give the opportunity for you guys to ask questions. And I warned everyone on the panel here that I think we're going to get a lovely, engaging set of questions. So don't let me down, all right? So thanks, everyone. And so we're going to go ahead and start with Ruben.
So thank you, Linus, and thank you to everyone else at the center. And speaking of personal connections, I actually was a law school classmate in the clinic, in the immigration clinic at NYU. So I'm a big believer in the work of immigration clinics and the potential that clinics have to train future social justice lawyers and leaders. And this is it's just an amazing venue and space, and great to see that you all have organized this event. So I know we're shrinking down, but enforcement is actually a really big topic. And I'm going to focus specifically on one aspect of enforcement, which is an area in which my organization, the National Immigrant Justice Center, has been involved in a lot of litigation and advocacy, and that's litigation and advocacy around the issue of immigration detainers and related Fourth Amendment issues. And I'll explain in a moment, for those of you who don't know, what an immigration detainer is. But I want to focus on that piece of sort of the enforcement machinery because I think it's key to understanding how it is that we've gotten to the place where we currently are, which is, an era of mass deportation. So everyone knows, Obama the administration deported close to 3 million people, which is about the population size of Chicago's, which is really mind-boggling when you think about it, that quantity of people was removed from the country. And I think a key way in which we got there, actually two key ways, was first ICE increasingly co-opting local and state resources and involving localities and state jurisdictions in immigration enforcement. And the second is an increase in automation of arrest and enforcement practices. And I'll sort of unpack what that means, but ICE increasingly has been increasingly automating that process, cutting corners, making it easy to apprehend people, often at the expense of our civil liberties in ways that impact not just immigrant communities, but also US citizens. And the litigation in this space has really, I think, opened up key debates in two areas that I think both my panelists will talk about. The first is the debate about the role of states in this enforcement regime, both in terms of what can states do to push back, and obviously there are of course jurisdictions that are eager to participate in this enforcement regime. So it's that key to understanding that debate is sort of the litigation in this area, and the second is the extent to which ICE can take advantage and use technologies as part of its enforcement regime. And we heard in the earlier panel some discussion of, I think Chantal was talking about, we're now getting to a place where DNA collection is possibly going to be part of this process, right? And so, and this is one area where ICE has been implementing certain technologies for a period of time. So like I said, at NIJC, we've been involved in litigation in this space, and most recently, we, along with our partners at the ACLU of Southern California and the National Day Laborers Organization in California, won a trial in a pretty significant and groundbreaking case involving detainers with national import. And I'll explain a little bit. Good to talk about victories. We often we face so many losses, and when we win, it's amazing, obviously. And I'll explain a little bit what the impact of that litigation moving forward. But first, for those of you who don't know, I just want to explain sort of what a detainer is. So, a detainer is basically, it's not a warrant; it's a form that ICE will issue to local law enforcement agencies. So, Hennepin County Jail or wherever notifying the jurisdiction that there's a person of interest in their custody, and asking that the locality, the local jurisdiction, hold the person for a period of up to 48 hours after their local or state custody will otherwise end. So somebody might be arrested on traffic violation, matters resolved. If the local jurisdiction complies with the detainer, the person could potentially be held for 2 days more than what they otherwise would have been exposed to. And that's sort of key. It's key to understand that because as courts have found, that period of custody implicates the Fourth Amendment in the sense that now the state is effectuating a new arrest, a new seizure that must be supported by probable cause. And so for that reason, the state is now potentially on the hook if there's some unlawful seizure or arrest. And that's important, and in fact, it's led to, this is one area of immigration law where there's been a tremendous amount of litigation in the state courts, right? We're often, as immigration practitioners, often used to being in immigration court and federal court, but the states have now, and this is throughout the country, begun to issue rulings on the legality or the lawfulness of local jurisdictions, assuming custody over people for that period of time in which their custody would otherwise end because they're complying with detainers. So the way in which ICE is using detainers is sort of different from how historically it has used them. In the past, early 90s, before, really what the detainer was just a request for notification primarily, right? That the local jurisdiction notify ICE when somebody was going to be released, and then ICE would come and pick up the person. But now the way it's been used is sort of deviated substantially from that, and now many jurisdictions have become an arresting agency, right, for ICE, arresting authority for ICE, and held people in their custody for immigration reasons. So a little bit of background about how they're issued. So there are a couple of different ways in which ICE agents issue detainers or requests to jurisdictions to hold people. One straightforward way is an ICE agent might come across somebody. There might be an ICE agent within a correctional facility, for example, and they might approach a person, interview them, and through the interview establish certain facts that would give them probable cause to then take custody of the person. That's one way, but an increasing number of detainers have actually been issued through really just a fingerprint match plus some database searches with no sort of interaction between the officer and the person at all. So just to explain how this works, so when somebody is booked into custody in a local jurisdiction, they're fingerprinted. The fingerprint is generally then shared with the FBI, which is linked to this biometric repository that's maintained by the Department of Homeland Security called IDENT. And if this fingerprint repository has some sort of some hit belonging to the person, in other words, that person might have there's some biometric match in that system, then the system will automatically generate a request that then goes to an ICE agent in some office who then runs database searches in a number of federal databases. Based on the results of that, the agent, or in some cases a contractor, right? Sometimes it's not even an ICE agent, let alone a trained immigration lawyer, will then make a recommendation or issue the detainer to the local jurisdiction. And that's how many people over the past 15 years have wound up in immigration custody. I mean, just to give you some numbers, and by the way, this program that I've just described I'm sure all of you have heard, it's called Secure Communities, but since 2008, I think it's been estimated around 2 million Secure Communities detainers have been issued. At the height of the Secure Community programs in 2011, and this was in the prior administration, over 300,000 detainers, Secure Community detainers were issued in just 1 year. So we're talking about a huge volume of detainers and arrests, and this has really explained how it is that we've gotten to a place of mass detention in this country. So I mentioned earlier the litigation that NIJC and I was involved in. We filed, this is the Gonzalez v. ICE case, which we filed was filed in the Central District of California, actually several years ago, but it only now only this year did we go to trial on a couple of issues. But it's a case that has national import because so within the Central District of California, there is an office called the Pacific Enforcement Regional Center, in which contractors sit in what one ICE witness at trial described as sort of a cubicle farm, where they're just getting these basically requests, or they're getting database information for individuals and then making recommendations to deportation officers to issue detainers. And these detainers are issued not just within the Central District of California, but they're also issued across the country in 42 different states. And so for that reason, this is a case that has sort of national impact because it implicates arrests across the country. So the Gonzalez case raised a number of claims, but the ones that were recently decided, one was sort of the question of whether ICE violates the Fourth Amendment in issuing detainers to places, to jurisdictions where, for example, legislatures have passed laws banning compliance with ICE detainer requests. The question there being sort of the legality in light of sort of sanctuary laws. And this claim really comes out of Arizona v. United States. So for those of you who know, it's a very landmark Supreme Court case on federal preemption. It involved a challenge to Arizona law, Senate Bill 1070, in which Arizona basically tried to pass a law that would have involved local law enforcement in the enforcement of immigration laws. Many of those provisions were struck down, and in doing that, the Supreme Court was really clear. The Immigration Nationality Act created a pretty, delineated system in which immigration enforcement really is a responsibility of ICE officers and federal law enforcement. And to the extent states can be involved, there are only there are narrow ways in which states can be involved in this process. One of which is through the signing of what's called a 287G agreement, which I'm sure many of you in this room have heard about. But the 287G agreement, is a reference to the statute, and if the local jurisdiction signs on to such an agreement and receives training and other resources from federal law enforcement, then they're able to participate in the immigration enforcement process. But even then, the statute is clear that this is permissible only to the extent it's allowed under state law. So a jurisdiction can sign on to a 287G agreement, but state law has to authorize such use and such participation in federal law enforcement. And so the court in Gonzalez held that ICE violates, to the extent it's requesting local jurisdictions to arrest individuals, keep people in custody for immigration purposes. ICE is violating the Fourth Amendment when it issues detainers to states where states have clearly found that, or have legislated that compliance with detainers is unlawful. And there are several places where that's been the case. Illinois, where I practice in, has a pretty clear sanctuary law on the books. California does as well, and in those jurisdictions, local law enforcement cannot honor detainers, and yet ICE is issuing detainers to those jurisdictions. That was one part of the decision in the trial, but the other one that raises some of these issues that Julie, I know we'll talk about later on, is that the court found that ICE also violates the Fourth Amendment in issuing detainers based on database searches alone, particularly because the databases that are searched are so unreliable. And this involved application of pretty settled Fourth Amendment law. So those of you who've taken criminal procedure know that, for example, it's totally permissible for law enforcement to rely on confidential informants, right? So somebody can write a letter, give a tip to law enforcement saying, I think so-and-so is involved in something shady. And the law enforcement officer can effectuate arrests, but even then, so the Supreme Court has been clear, that's allowed, but the informant has to be reliable. There has to be some indicia of reliability. Has this person in the past, for example, provided reliable tips such that it's consistent with the Fourth Amendment and proper for Fourth Amendment purposes to rely on that information. That's pretty much the same concept that was at issue in this case. And the court found that the databases that ICE currently relies on are unreliable in so many different ways. And I'm not going to bore you with the details of all of the databases, but just to give you some key examples. So we had one expert witness, pretty preeminent immigration lawyer, who testified about USCIS is the agency that issues most immigration benefits, green cards, citizenship, etc. And she testified about one key flaw in the main USCIS database. This is the central index system, which has some basic data points about people who have had some interaction with the agency before. And that key flaw was that, as those of you who are immigration lawyers here know, if somebody naturalizes, applies for citizenship, and they have children who are under 18, that child automatically becomes a citizen under operation of law. They don't have to do anything. You can file an application. The child can file a really expensive application, a $1,200 application, for a fancy certificate from the agency saying you also are a citizen. They don't have to. Only the parent has to file his or her naturalization application. So that's the process. So the database might reflect that the parent has become a citizen, but it's not going to reflect that the child who's automatically become a citizen is a citizen. And so because of that structural flaw, that database has pretty much misrecords the status for many U.S. citizens. They're reflected in many cases as lawful permanent residents. And so when we hear about stories across the country of U.S. citizens being subject to immigration detainers and ending up in immigration detention, one explanation has been in many of those cases that the databases incorrectly reflect their status. So that was just one of the flaws in the databases that was sort of exposed at trial. There were many others. Like I said, I'm not going to bore you with all the details, but the judge found that, look, immigration law is exceedingly complicated. Even determining whether somebody is a citizen is complicated. And so for that reason, and taking into account that none of these databases were designed specifically for the purpose of determining whether there's probable cause to deport somebody, they're just not reliable sources. And particularly when the agent is not meeting the person in most instances who's going into custody, they're not reviewing paper files, they're just looking at printouts from databases. So that was the finding. Those were the key findings in the court. We're still working out a judgment in the case and hope to have some resolution in the near future. And like I said, it's a case that will have national significance. And it also, I think, sort of foregrounds two issues that are just ongoing debates in this area. Like I said, first is the continued importance of advocacy on the state level regarding sanctuary policies, and to the extent that we can support grassroots movements to enact positive change in state legislatures, that would be a really great thing. And then the second is, I think the Gonzalez decision really sort of is exposing what has previously been very unknown or not well understood aspect of immigration enforcement, and that is the extent to which ICE is relying on automation of arrests and its processes. And this is a loss for the agency, but I don't think it's the last that we're going to hear of it. Already we know that technologies and database information is being used in other aspects of immigration enforcement, and it's something that we all have to be vigilant about, not just in litigation, but also in advocacy.
Hi, so for those of you who don't know me, my name is Anna Patratz-Acosta, and I'm a professor at Mitchell-Hamlin, which is just across the river in St. Paul. But for today, I am kind of going to be relying more on my other title, which is that I'm also a member of the executive committee of our local chapter of the American Immigration Lawyers Association, and I also serve as the advocacy chair for our local AILA chapter. And for today, just kind of related to Ruben's comments related to advocacy at the state and local level, I'm going to be talking a little bit about how attorneys and activists can work with partners at the state and local level to challenge some of the more problematic actions of ICE. So first thing that I wanted to share, so this past Monday, I was actually in Washington, D.C. at an advocacy chair meeting with AILA National, and one sort of overarching theme is that not a lot is really going to happen at the national level. We're sort of limited to our Congress performing oversight activities against ICE and the Department of Homeland Security, and there's not a lot of hope with pushing through legislation. But what a lot of other advocacy chairs around the country are focusing on is our actions at the state and local level. And what I'd like to talk about are some of the things that we've done here in Minnesota as far as kind of working at the state and local level to effectuate change. So before talking more specifically about some work that I've done and others have done with the Hennepin County Sheriff's Office, I'd like to just kind of talk about some of the work that's been done by many people in the activist community and within the local immigration bar, including by many people who I'm seeing in the audience to sort of effectuate positive change at the state and local level. So for example, this past year, we did have proposed legislation in the Minnesota legislature to provide driver's licenses for undocumented immigrants. Unfortunately, that wasn't successful, but we're hoping that a lot of the work that was done this past legislative session will provide us with the means to sort of push forward this legislation in the new session. There was also a proposal for a statewide U visa certification bill, so we think that will also be something that we could work on in the future. We also have, supporters in the state legislature, and we've had some success working with them as well. So for example, over this summer, we had a hearing with the a committee of the Minnesota State House of Representatives on immigration issues happening at the border. And the purpose of this, obviously the Minnesota State Legislature can't do a lot to effectuate change on this front, but it really more than anything, it was to raise awareness of issues happening at the border and then kind of tie them to immigration enforcement and issues we're seeing within immigration law here in Minnesota. And once again, I just want to stress that all of this advocacy work that I've talked about and that I will be talking about specific to Hennepin County is really a collective effort, and it's sort of a long game. And this is the work of a number of individuals and organizations who've been working on these issues for years. And I think one thing that is always important to recognize as far as advocacy work is concerned is that what's happening is bigger than all of us. And we really need to come together and work together in order to effectuate change. And that's really how we're going to sort of make this happen. So I just want to make sure that I'm acknowledging all of the work that's been done by a number of wonderful organizations here in Minnesota to effectuate that change. So kind of moving on to the work that has been done locally with the Hennepin County Sheriff. This is both related to the election, the midterm election for the Sheriff's Office that happened in November of last year, as well as some efforts that have happened after the election. So I think most of you in the audience, I recognize a lot of faces, are from Minnesota and are probably from the Twin Cities, But just to provide some background for everyone in the audience, before January of this year, the sheriff in Hennepin County, and Hennepin County is where we are right now. It's where Minneapolis is located, and Hennepin County is the most populous county in Minnesota. The sheriff in Hennepin County was Rich Stanek. And for those not familiar with former Sheriff Stanek, he, when he was in office, engaged in a number of problematic actions, I'll say. Yeah, I'm just kind of trying to use my more political terms. Problematic activities, at least from the immigrant rights perspective, with respect to his relationship with ICE. So just to give a few examples, even though Hennepin County had a broad policy to not honor ICE detainers, Sheriff Stanek did engage in a number of activities that sort of demonstrated a pretty cozy relationship with ICE. So one example was that he regularly allowed ICE into the jails to interrogate people who were being detained there. The sheriff's office also had a policy where they would notify ICE when someone who was foreign-born or a foreign national had been arrested and was in custody at the Hennepin County jails, and then they would also notify ICE when someone was going to be released. So even though Hennepin County didn't have a formal policy of honoring detainers, it would tip off ICE and say, hey, this person's going to be released on this day at this time, so that they could send an officer to arrest them. So it sort of undermined the policy of not honoring detainers. Additionally, Sheriff Stanek also appeared in a New York Times article about a year or two, I think about 2 years ago, a year and a half ago, where he complained that he was not able to do more to facilitate better cooperation between the Hennepin County Sheriff's Office and ICE. And this was sort of in a response to being placed on Department of Homeland Security's sort of bad jurisdiction list or sanctuary jurisdiction list. And he sort of took issue with that and wanted to say, no, I'm a friend of ICE, so please don't place me on the list with other sanctuary jurisdictions like California or other parts of the country. And related to this, the former sheriff was also a pretty vocal supporter of President Trump and flew to Washington, D.C. on a number of occasions to meet with the president to kind of discuss how state and local law enforcement maybe could have a better relationship with ICE, among other issues. So kind of knowing this background a lot and recognizing from an immigrant rights or an immigrant activist perspective how problematic the policies of Sheriff Stanek were. So me personally, as well as many others, recognize that really the only solution to effectuate change in Hennepin County was at the ballot box. So to kind of paraphrase my husband, as far as when I decided to get involved in the sheriff's campaign last year, what he says is that Rich Stanek pissed off the wrong lady. So kind of to explain how I got involved in the sheriff's race, and there were many others that were involved in this race too. So my small role in this was, or I guess before kind of talking about my role in the election, or what I did to work on the campaign or the election. So the challenger, there was a challenger to Sheriff Stanek in the election last year. The challenger was a police officer named David Hutchinson. He also goes by Hutch. And prior to the election, he was a police officer with over a decade of experience. And when he decided to run for the sheriff's office, he was working for Metro Transit as basically a beat cop, or he worked in the transit office. And the thing to keep in mind about Hutch is that he really isn't a politician. If you meet with him, he's not terribly interested in politics. He's just kind of a regular guy who's worked in law enforcement for a long time and just thought he could do better than Sheriff Stanek. So that's why he decided to run. And I met Hutch for the first time when I went to the DFL, or for those of you not from Minnesota, DFL is the Democratic Farmer Labor Party, which is kind of the Democratic Party in Minnesota. So I was at the state convention and I met with him and just kind of talked with him briefly and introduced myself as an immigration attorney and as a professor here in Minnesota. And about a month or two after the state convention, Officer Hutch at the time reached out to me to ask for some talking points or just asked me to kind of explain immigration law to him because he didn't have a lot of background on it. So actually very close to here, there was a coffee shop not far from the law school. Myself and Kathy Mochio, I don't know if she's in the room right now, but Kathy Mochio, who's a professor here at the University of Minnesota Law School, the two of us met with Hutch and his campaign manager and kind of explained a lot of the problematic things that were happening in the Hennepin County jails and the sheriff's office related to the relationship with ICE. And from that, he was able to develop some talking points that were taken directly from that conversation we had that he incorporated into his campaign. Additionally, he appeared on an episode of the podcast Immigration Nation. It's a Immigration Explainer podcast that's hosted by another attorney from the Twin Cities, Carolina. She actually recently relocated to DC and is working for the Senate Judiciary Committee. But before that, she had a podcast and had invited Hutch to a live recording of her podcast to kind of talk about the campaign and talk about his position on immigration issues in the campaign. So that was another thing that I kind of helped to facilitate, I guess. And then the last thing that myself and then hundreds of other people in Hennepin County engaged in was door knocking, just kind of the regular campaigning or shoe leather advocacy. So I spent many weekends last fall knocking on doors in Minneapolis and in the first ring suburbs, which tend to be a little bit more liberal in Hennepin County, to just let them know about the sheriff's race and how important the sheriff's race was to effectuating positive change as far as immigration policy was concerned. And with door knocking, I just really, in my experience with this, I really want to stress that a lot of us are very focused as far as elections are concerned on national campaigns. So we're focused on the presidential election. Maybe if there's an important governor's race or a Senate race in your state, you're focused on that. But I think it's really important to also focus on smaller elections. So the county sheriff, the county attorney, these are really places where you can get progressive people into office that can kind of work with you to effectuate change at the local level. So I think it's important to focus on these elections. And as many of you know in the room, these efforts sort of bore fruit, and Hutch won the sheriff's election by several thousand votes. So it was a very, very exciting time for a lot of us in Hennepin County when he won that election. And then as far as what happened after Hutch took office in January of this year, kind of following through on a lot of issues that he campaigned on, what he did, or what his office did, was actually formed something called the Community Advisory Board. And he invited members of the community that sort of worked on specific issues. So there are people who work in addiction recovery, mental health issues. I'm trying to think of the other ones. And then of course, immigration. So I was invited to be one of the immigration advisors to the Community Advisory Board for the Hennepin County Sheriff's Office. We meet periodically and kind of discuss proposed policies or issues that affect the Hennepin County Sheriff's Office. And after I was invited to be part of the Community Advisory Board, I reached out to a number of other attorneys who are part of the local immigration bar to kind of help with developing some recommendations that we presented to the sheriff. So the big organizations, and I want to make sure I recognize them, were Mid-Minnesota Legal Aid, the Advocates for Human Rights, and then Immigrant Law Center, as well as some of our colleagues here at the University of Minnesota. So kind of working with them, we came up with a number of policy proposals. And we're kind of working, some of them haven't been implemented yet, and it's sort of a work in progress, but we have been able to effectuate change or kind of get them to shift their policy in a number of key areas that have had a pretty positive impact for foreign nationals who are arrested or who are detained in the Hennepin County jails. So the first of these is that the Hennepin County Sheriff, as a policy, no longer contacts ICE immediately after the arrest or booking of an individual in the county jails. They instead rely on the databases. So it's sort of like we don't have to take that extra step to help ICE when they already have that information through the databases when they run fingerprints for someone who's booked in the jails. They also have phased out, the idea is that they're going to be phasing out notification, notifying ICE of a person's release from the county jail unless it's required under a Minnesota statute. They've sort of reiterated their policy of not honoring detainers. As far as interrogating individuals being held in the Hennepin County Jail, right now the policy is that they're still allowing it if there is a request made by ICE. However, one sort of major change is that they no longer have a dedicated space for interrogation. So because there's no longer a designated space where they can conduct interviews or interrogations of individuals in the Hennepin County jails, it's sort of limited ICE's ability to engage in questioning. According to the sheriff's office, the number of people who are interviewed by ICE has gone down pretty significantly. Let's see. And there are a couple of other key areas as well. We're also working together with some of the nonprofit organizations, MMLA and Immigrant Law Center and the advocates to develop Know Your Rights information that is going to be provided or that is provided to individuals before they're questioned, and these sorts of things. And as I said, it's sort of a work in progress. We're working together with the sheriff's office to sort of push them and try to improve things. But so far, it has been a pretty positive working relationship, and I'm pretty happy with the results so far. So kind of in closing, I think some of the things that I've described are definitely things that can be replicated across the country. I definitely would recommend that even though maybe your state and local law enforcement office, it wouldn't, for immigration activists or immigration attorneys, maybe not a natural ally, but I think it's worth working or reaching out to them and kind of working with them, because there are many areas where state and local law enforcement, their interests may be aligned with immigration attorneys or immigration activists. They want to make sure that there's good community policing, that individuals aren't afraid to come and ask them for help if they need assistance from state and local law enforcement. And they also are not particularly interested in being sued if something goes awry when they're holding someone with an ICE detainer. So I think there are a lot of areas where you can have common ground and effectuate change by sort of working together with state and local law enforcement. So I would definitely recommend this sort of work as a way to effectuate change. So don't underestimate the very most local of elections, and also kind of working with different partners that may be a little bit outside of the box. Thanks.
Good morning, everyone. Oh, okay, all right. Y'all aren't asleep yet. Cool. Lunch will be served very soon. My name is Julie Mao. I am an immigration attorney and a deputy director at a new law office called Just Futures Law. It's a women of color founded law office. We work at the intersection of immigration law and criminal law, and particularly working with grassroots communities as well to address immigrant criminalization from policies that limit police or sheriff collaboration with ICE, to trying to limit data collection by local authorities to try and erase police gang databases. So really excited to be here. It's been like similar to Ruben. You don't know this, but Ruben and I previously knew each other from going to law school and an immigration clinic together. And we've spent almost nearly now a decade in the immigration deportation field. Me personally working mostly in Louisiana in the Deep South, and have just been a real privilege to work with lawyers and in sort of, in the front lines of this work, and I had also the privilege of working with Linus and the Release Minnesota 8 family. So really honored to be back in the Twin Cities. So what am I here to talk about? So Ruben, excuse me, and Anna have spoken really eloquently about ICE detainers, sort of the jail access point and database access point between local police and ICE. So I was hoping to spend, though I do some of that work in North Carolina, DC, somewhat Chicago, I was hoping to spend more of my time dedicated to sort of forward-looking and thinking about, okay, currently immigration enforcement is very much jail information sharing, right? Fingerprints that are sent to ICE and checked against their database. What will immigration enforcement look like sort of now, but like 5-10 years down the line? And how can we be sort of forecasters as attorneys and people in the movement to address those types of enforcement? So we're not letting enforcement get ahead of us. So given that, I am hoping to talk a little bit about technology and surveillance-based enforcement. And if we do have some time in the question and answer section, if someone wants to prompt me, I'm happy to talk a little bit more about sort of general pointers on how immigration lawyers can work with organizers. But some context setting for technology and surveillance-based enforcement, right? So what is it and how did we get here? So one recognition of this technology surveillance field is that the criminal legal system, the criminal justice system, mass incarceration has been going high tech for quite some time. Are there any criminal defense attorneys or federal defenders in the room? You're gonna raise your hand. Okay, all right. Some. Some of you might know that we have a really mass incarceration, but also supervision system for pretrial individuals and probation, right? We have the numbers are around like 4.5 million individuals at any given time in the US who are under some form of pretrial or probation supervision. And a lot of that supervision, particularly at the local level now because of limited resources, is e-incarceration, some form of electronic monitoring or surveillance, whether it be an ankle shackle or DNA type samples, DUI related alcohol testing. The other, context setting is, local police have been purchasing technology for quite some time. We are talking about things ranging from scary things like facial recognition to license plate readers, stingrays, which basically simulate a cell site tower so that they can kind of copy any text that you're sending. And really they're using it not in special circumstances. Like they're not using it, through a criminal warrant. They're using it in everyday policing practices. And we kind of know in the immigration context that like whatever is done in the criminal justice system, the immigration agents like to copy or adopt, right? It's not like there's this like, concrete wall between these law enforcement agencies. They talk, they go to conventions together, they share strategies and tactics. And so immigration enforcement has been going high tech as well. Can I see, are there practicing immigration attorneys here today? All right. Like how many of you guys have clients that have ankle shackles, for example, and are monitored, right? Doing lots of check-ins, pretrial things. Yeah. So I would argue that another sort of context-setting norm is that I would argue that when it comes to tech-based enforcement, ICE and DHS are actually now the main drivers of tech-based enforcement strategies for two reasons. One is that it is harder for immigrants and those at the border to assert their rights. Often they lack basic rights. And for example, the federal crime of entry and reentry, those are status-based crimes. It is very easy to get criminal warrants, and sort of tick off the box of Fourth Amendment requirements for federal prosecutors to get to use these technologies on non-citizens. And secondly, there's a massive funding of DHS by Congress specifically to do tech-based smart what they call smart enforcement strategies. So you're seeing drones at the border, right? But you're also seeing biometrics devices, fingerprint, facial iris capture devices being given to ICE agents in Minneapolis to fingerprint people or capture other biometric information on the streets. And that's because of the immense amount of funding that DHS has at this time, to the point where they have so much money, they're re-granting that money to local police so that they can purchase similar technologies. So I'm gonna go through a couple of examples of how ICE conducts tech-based enforcement. And I'm gonna warn you that probably my goal is to go from talking about that information, perhaps getting you paranoid about that information, but then maybe bringing it back to what are ways and strategies to empower us to go from paranoia to empowerment. Let's see if I can do that. So a couple of ways that ICE has been conducting tech-based enforcement. So one is local government granting ICE access to local government databases, right? I just talked about how we have really large technology-based enforcement in the local criminal context. So local governments are keeping a lot of information about its residents, right? Driver's license information, date of birth, address information, maybe electric bills, gas bills, right? And so there are, in many localities, sometimes unbeknownst to many government officials, the databases are being accessed. ICE has licensing access or some sort of back-end access to information in those databases. We currently represent, for example, a activist in Washington State where she was located by ICE through the Washington State driver license database. So that's the first sort of example. The second example is tech companies who are private contractors for local governments that help the government maybe set up software or data, but then collect that data and sell it to other law enforcement agencies like ICE. So the sort of current famous shocking example is Vigilant Solutions, which is a license plate reader company that a lot of local police departments use. They sell the license plate reader as well as the software for patrol cars. But then they also, whatever photo capturing of the license plate is done by that police car camera, they save that picture. They capture it into their own database and they sell and monetize that picture to another agency like ICE. So in places that have Vigilant Solutions, police departments that use Vigilant Solutions as their third-party contractor, for example, if you take a license plate picture, right, it has the license plate, it probably can run, therefore, the person's name. It has the location, right, of the license plate, and that information automatically pings to ICE so that they can search their own databases to see if this person is someone that they're looking to apprehend. And in that way, actually, secure communities is very similar. It's like an old model of that, where it's like the fingerprints is the thing being shared. In these contexts, this future technology, it's, you know, these tech devices are creating that information, whether it's license plate stuff or driver's license databases. Okay, so the second scenario is tech contractors that manage technology data for local governments that sell the collected data to ICE. And then the last category is technology and data that is being used by the actual federal agency itself, being used by ICE. So currently, federal agencies like ICE, like the FBI, are marshaling, you know, an unimaginable amount of data. Have y'all heard of like people in the immigrant activist community like protesting Amazon? Like, have you guys heard a little? I see a little nods. So it's like really strange, right? Like, why are people protesting Amazon? And that's in part because Amazon owns the cloud data services to which so much of this ICE data on people, on men, you know, not just immigrants, just downloading and trying to marshal and collect this data. ICE doesn't have the money nor the technology to host that amount of data, and it actually needs third-party contractors to host that data, and the one place with that amount of space is Amazon, okay? And so the federal agencies are pooling that data into these, you know, e-cloud data servers, and then they're using data analytics companies, like, for example, Palantir, to mine that data. So, for example, locate, you know, for a particular person, data point, you know, what are their social media handles? We're trying to get to empowerment, okay? You know, what are their social media handles? What are they saying? Maybe, you know, using LexisNexis to find, social security numbers or driver license addresses. So they're trying to pool all that data and using third-party analytics companies to sort of create profiles on people. And the ultimate goal is actually very simple. It's actually the same thing as like the Detainer situation. It's like finding the person and the location, matching the two together, you know, home address, person, and trying to apprehend the individual. So I think now that I've gotten you guys all paranoid, I actually think that we are at a really watershed moment, similar to where we were maybe a decade ago around secure communities, where advocates and litigators are trying to figure out litigation and policy strategies to address this new wave of tech enforcement. So I can't talk about all the policies now, but we recently issued a report with Mi Gente called Take Back Tech. You can, you know, look at like a 40-page report listing all the existing policies that are being passed around the country. It's like very vibrant time. But there's three sort of categories. One is policies that ban certain uses of technology or ban certain collection of technology. So, you know, places, like California is trying to ban, a whole state is trying to ban police use of facial recognition, and a bunch of places in Massachusetts have already done that. So that's one category. Two is policies that minimize data access. So for example, you know, there are many states that are trying to figure out driver licenses for undocumented or immigrants who could not otherwise be able to get licenses. Well, making sure that legislative strategy is in parallel with the strategy to limit how ICE gets that information, right? Because we don't want it to be that, you know, getting a driver license means your address is known to ICE. And then thirdly are policies that essentially limit third-party contractors storing, monetizing, and selling that information. So making sure that local governments have policies about who are there third-party contractors, and to the extent that, memorandums of agreement explicitly say this information cannot be stored by third parties and shared and monetized. So I think the last quick thing, and then we need to go, is that those are all policy areas, right, that I've just mentioned. I think what we're hoping in the next sort of discovery is to like an open call to litigators to think collaboratively with us about developing legal challenges, right? Like when secure communities came up, we put our heads together and tried to figure out like detainer litigation. We couldn't stop the fingerprint sharing, but we could, figure out little hooks around Fourth Amendment law to challenge ICE detainer litigation. So what is that gonna look like for this next generation of tech enforcement? The one sort of bright spot on that is that federal criminal defenders, including in many Midwest states where reentry prosecutions has been surging, have been thinking through statute of limitations challenges to reentry prosecutions. Most federal felony crimes have a statute of limitations of 5 years, and many individuals, right, have been surveilled by ICE on databases for far more than 5 years. And so thinking through sort of statute of limitations challenges and sort of using the government's surveillance of people against them. So I'll just leave it at that.
Wow, so sort of sobering aspects, right? This is not necessarily going to be a day of happy thoughts, but it's certainly, hopefully, a day of thinking about some of these implications. So I think there are microphones, and if people want to go ahead and ask a question, we're going to go ahead and get there. I have a thought too before people have, and I leave this open to all of you, but I do have a thought here is, first of all, when we're talking about data collection and we're talking about surveillance, I think one thing it's hard in my mind in terms of being in the immigration field is to talk to people and say, how does this immigration enforcement affect you if you're a citizen, right? And I think what's clear is the question of surveillance is they can't selectively only surveil non-citizens. And so I just, if you had thoughts about how that works, not only in this context of tech, but in detainers, this is the idea, right, of we've long had an American tradition of we don't have a national ID card for lots of reasons, but we are getting to a point where they're building it anyway. So anyway, I just thought if you had a thought about that.
I think it kind of like gets to the little like the general tips that I was going to talk about too, is like, I do think that so many communities are under attack right now, and it's really hard for us to just stay in our lane, like both as people, like there's so many things to get outraged about these days, and also if we just think of incarceration, immigration detention, immigration surveillance as immigration issues, we actually don't have enough power to win. Because we kind of are like the Willie Hortons of like today, like immigrants with criminal convictions, right? Like those are the folks who are most being attacked and vilified for today, right? Many other people who continue to be attacked in similar ways. And so I think thinking through, how do we build intersectional movements that brings in more of the civil liberties community and the surveillance context, bring in more of the, police accountability, Black Lives Matter sort of movement, who are also having very similar conversations about mass incarceration and e-incarceration. And I think also to Anna's point about like making sure that we're building broader community strategies, thinking about local electoral politics, if, on the federal level, it just feels quite helpless some days. I think, those are, I think thinking about it as broadening it out as a larger movement, both in terms of litigation strategy and policy strategy, really makes sense at this moment.
Yeah. Can I risk kind of being tinfoil hat a little bit about the, yeah. So I think as far, kind of going to your question about well, it's not hurting me or it's not affecting me, I think that's maybe a little bit naive. And there were reports earlier this year, for example, that the federal government is keeping dossiers on immigration attorneys who are working at the border. And I think, too, we have to kind of be cognizant of the fact that they're not just surveilling our clients, they may also start to surveil us and other people who are activists, who are attorneys or journalists. And kind of from the attorney perspective, we maybe want to kind of think outside of the box and sort of think about professional responsibility or concerns like the duty of confidentiality and how to challenge some of these things because, so for example, if you have information on your phone, client information on your phone, and then the government, when you go through customs, asks to look at your phone, that may implicate your professional duties as an attorney. So I think we also kind of have to think about not just about how it's impacting our clients, but maybe how it's going to start to impact us. Sorry, that was probably freaked us all out a little more too.
No, I mean, but it's true. I mean, the leaked information about the tracking of immigration attorneys came about through really a very back channel way. It was not something that people suspected that they were being targeted, and then they only later on, and this is in Southern California, where they were able to find it. So tin hats maybe for everyone, right? I mean, I think it's possible.
Hi, I'm Catherine with the Interfaith Coalition on Immigration, and I'm curious from each of you, as we look at building out a Minnesota sanctuary state, what would make it like state of the art? What are the things we should make sure we built in? I heard about the not complying with detainers, but from technology, what are the things that we should really be looking at in Minnesota?
Yeah, well, I guess as far as making, and I'll say this is somewhat, so I live in Minneapolis now, but I grew up in greater Minnesota. I think the idea of making Minnesota a sanctuary state, I think we're pretty far off from making that happen, just kind of practically speaking and politically speaking with the politics involved in greater Minnesota. I think probably kind of incremental steps, which I sort of alluded to, is just sort of working with state and local law enforcement and building those relationships. So for example, in greater Minnesota, if you talk to the local police departments, they often are on board with a lot of the things that we're talking about. And I think the other thing too that is important, and I know Linus has done some writing on this, but the language that you use as well. So sanctuary city or sanctuary jurisdiction may kind of have tainted connotations depending on what part of the state you're working in. But if you talk about or if you call it a separation ordinance or saying we only want to enforce local laws or framing it in that way, then people might be more receptive to the argument. So I think I would say just kind of being mindful of your language and doing the long work of building those relationships, I think, is how we can make that happen.
Just on this idea of what can Minnesota do, right? I mean, I think there's a lot of things that if you look around, there are already examples. Driver's licenses is one example, but of course, there's a question now, right? Driver's licenses, and then suddenly we're storing a lot of information on people who are there. There's the issue of a lot of the work that I've been doing, and we've been doing some work lately in Minnesota legislature, has been on the criminal justice side. Mm-hmm. Things as simple as, from the very technical, from things like post-conviction relief and how to get post-conviction relief for people who might be facing deportation, to the very, to things like how much control do states and the state government will have over local detention centers, right? I mean, there are efforts all on that area. I do think it's imperative, no matter where we go in terms of that community, is to recognize, to an extent of what Julie was talking about, this is very interconnected. We're not just talking about, we are now having a situation where we're implicating not just the criminal justice system, we're implicating the benefits system, we're implicating the healthcare system, we're implicating family law system, right? There's a very high profile case in Missouri where a woman is losing the parental rights of her child because she was in ICE custody and her child is getting adopted, right? I mean, all of these things are interconnected. And the question really becomes like, it's not just a matter of immigration enforcement. And I think Julie put it right. We are, it's a weird space for me, because when I first started, nobody was talking about people with criminal records who are immigrants should be protected at all. We've made some strides, as politicized as it's gotten, but it really does going to be taking an idea of this overall aspect. So I do think there's a lot. It could be probably a wish list depending on how you go about what's going on. And it's going to be very interesting to see that states' rights actually being played out in this area. But I do think it's important to understand that there's a lot of intersection and a lot of things. For those who are vested in immigration communities, it's important to continue to push the idea that this isn't just, I think what I say is like, it's not an issue of mercy. It's not an issue of being kind, right? Which it is, but it's way more of an issue of self-preservation. Like, it is what we want our community to be. Like, what does it mean to these communities? Because there's a certain vision that's out there, and if we're not careful, that vision is going to win out. So that's what I'll have to say. Sorry. It's a Minnesota question, and
Yeah, that's true, though.
do you have a...
One other thing I would add is just that, I mean, there's a reason why companies like Amazon and Palantir are so interested in all of this, in this space, and it's just a huge profit motive behind all of this. And so, one great development that we've seen in states like Illinois and now California is banning of private prisons in the state. And that's, another area of advocacy that is really important.
My question arises from a very specific circumstance and perhaps has some practical implications. I am from the Duluth area, and I was recently at a rural school board meeting in which a person stood up and said, "I've been hired as a census taker, and when I'm done asking my questions, I put on my political hat." And she went on to describe some of the things that she would talk to the people about. So I was interested in the Fourth Amendment aspect as a confidential informant of a census taker, and sort of the interplay with census and where we're headed with that. It could be a very big door that I've just opened, but I am very curious to get your take on that issue.
Maybe I'll start. Yeah, I mean, I think the census question about, right, the immigration status question has been in litigation, and I believe is still enjoined for the 2020 census, right? That being said, there is an executive order from Trump after the Supreme Court decision that's trying to, again, go back to other databases to try to mine them to sort of match people to match census taking to the additional database information from localities. It's, I think, a place, again, it's similar in the sense of like, it's an all hands on deck situation, and we're gonna need structurally a building of long-term support to figure out the fix. For now, it's enjoined for 2020. I think mindful of how the first panel was talking about the history of immigration, the thing to understand about the census is that the census was actually used in Japanese internment, right? The race box and home addresses were taken by the census agency, and that information, that list, was transferred to the Army for them to then go and incarcerate and intern Japanese Americans. And so for now, because of that history, the Census Department has some very strict legal operating procedures for when and if it can share census-based information, even within other federal agencies. But we've seen how norms and policies have certainly been can be destroyed within an administration.
And the only thing I'll add to that is the census is something that there is quite a bit of attention now on this, and there are organizations who are working on making sure of pushing out a fair census and doing that kind of work. And it is, it's something that is extremely, what's terrifying, like Julie mentioned, is that yes, there was an enjoyment. And when Trump essentially went out and said, we're not going to fight this anymore, he basically said, we're not going to fight this anymore because there's other ways to gather that information. And I think, as we just heard from Julie, what they think the other ways are.
I'm a public defender in Ramsey County, which is just the neighboring St. Paul, Minnesota, right next to Minneapolis. And I just got an email from an attorney in our office this morning that I think is relevant. We have a very large Hmong population, and Minnesotans will know who those are, but we had a huge influx of refugees from Laos back in the 70s and 80s after the Vietnam War. A lot of them came as refugees from Thailand and resettled in the US, and we have a majority of them settled either in California or Minnesota. So there's an attorney with the Immigrant Law Center of Minnesota who advises the attorneys in our office about immigration consequences of any criminal cases that are pending, because there are such huge collateral consequences now of immigration status. So this is the email that I got from the attorney in my office. It said, I've been emailing with Susan Jorgensen, who's the wonderful attorney from the Immigrant Law Society, about immigration consequences on a case. My client is Hmong. He's from Laos and has been in the U.S. since 1980. She included the following information, quote, worth mentioning to him that the current administration is actively working to get Laos to accept its nationals back. His deportation could become a reality sometime in the near future. And then the attorney says, this is the first I've heard of this, so I thought I would pass it along, as a lot of our non-citizen clients are from Laos. So this is a client who's been here almost 40 years. And I don't really know what to say about it, except it's horrifying.
Yeah, there was a wonderful exhibit in the Minnesota History Center that looked at the history of the Hmong in the United States and the CIA secret war, and the understanding, of course, that for a long time, Laos did not treat the Hmong as citizens of Laos, right? They explicitly said they're not citizens. So this idea of these, and this is what's happening, is it's become visa sanctions and trade agreements are now within this realm of deportation. And there is understanding that right now there is negotiations for Laos to suddenly agree and reverse their own policy and start taking people who have perhaps either old immigration orders or ongoing ones. So. Any more questions? We have a few. Okay, great.
My question relates to the Hennepin County Sheriff situation. I'm a member of the group called MoveOn.org, and last year we were working on the immigration issue with the county jail. And we interviewed Minneapolis Councilwoman Marion Green, who had just taken a tour of the jail and the booking process. And she told us that the county still uses a lot of hard copies, so they have files on the inmates in the jail. And when someone comes in who gives their birthplace as not the United States, a pink form is placed into the file with all the other pieces of white paper. So it becomes very obvious who was a foreign-born individual. And that's how, when the person is due to be released, ICE gets the phone call. So Hutch pledged that he would change this, and I wonder if you know if that has changed.
That's actually I'm not sure how much I can say. It's an issue where we are, on the pink slips that go in the files during the booking process, it's kind of something that we're actively working on. I think the issue as far as asking the citizenship question or kind of, and this is, I think, is public information. So the reason why they are saying that they do need to ask the question, it's just kind of for logistical reasons. There are certain countries, if you're a national of the country, you do have to notify the consulate if a citizen of that country has been booked into the jail. So that's their justification for asking the question in the first place. There's a difference of opinion. So the attorneys that make up the subcommittee that are advising the sheriff, we've proposed some solutions as kind of a workaround, but it's kind of like a work in progress. I'm not sure about the current status of the pink slip that goes into the file during booking, but I know that the citizenship question, it's kind of something that's a little bit of a work in progress. And one complicating factor is that our subcommittee can provide recommendations, but ultimately the entity that advises the sheriff's office is the Hennepin County Attorney's Office. So we can provide our recommendations and give our legal research, but ultimately it has to be cleared by the county attorney's office. So that's a little bit of what's going on behind the scenes. And I think most of it is public, or it's kind of been expressed publicly as well. But that's one area, the citizenship question, that's sort of a work in progress that we're hoping to make, we're hoping to advance that part of it.
Yes, this is maybe naive, but with the airport, Minneapolis-St. Paul Airport now going to electronic check-in instead of a paper if you come into the country here, I'd like to know the ramifications of that and if there's any danger to people who hold dual citizenship. Will it be taken? Do you see in the future that it might be taken away?
I mean, there has been such a system in place for a while. It still has flaws. So one finding in the trial, for example, that I was a part of was that this entry-exit system oftentimes only captures one side of the story, right? It might capture an entry but not the exit, and so it gives partial information. But people, you can come in on a foreign passport, and so you might be, or have a foreign passport on you and be recorded as somebody who's potentially a foreign citizen, and so there's the potential for that sort of data capturing that can produce sort of misleading information for enforcement officers.
I mean, I think, we think of the border as an existential thing that happens. Like, we don't even think about Canada as a border, right? When we think of the border, we just think of the border to Mexico, when in actuality, because of the way we've prioritized DHS as this surveillance, like, police agency, the border, as they define it, is like, transportation nodes, which essentially are airports, bus stations, and like train stations, as well as the northern and the southern border. And so I think we're gonna see, right, we're gonna see a lot of surveillance or data sharing when it comes to places that I think people who are not immigrants have not seen them. And And in part, I think that's sort of what I was trying to explain is like immigrants are often the ones, because they'd have less rights to assert, or structurally, are not represented and have a hard time asserting their rights, they're often the first to be experimented on, right? With the way that surveillance happens, it impacts so many of us. And so if we want to fight surveillance, we have to be willing to fight for the people who are the most marginalized and vilified.
All right. So without further ado, lunch.